Time is 4:05. This is a meeting of the Sunshine Ordinance Task Force's Education Outreach and Training Committee. Could we have roll call, please?
Yes, Mr. Chair. Member Manny?
Present.
Manny present. Member Costa?
Present.
Costa present. Mr. Chair, there is a quorum.
Mr. Clerk, are there any changes to the agenda?
Yes, Mr. Chair. Item number 3 has been removed because to hear that case, both members would have to be recused, and so we would lose quorum.
Thank you. Okay, with that said, Mr. Clerk, will you call the first agenda item, please?
The first agenda item is adoption of June 9, 2011 regular meeting minutes.
Is there a motion to adopt the minutes?
I make the motion to adopt the minutes.
I'll second. Sorry. Is there any public comment on the adoption of the last month's meeting minutes? Excuse me. Seeing none, public comment is closed.
On the motion, Member Manny. On the motion, Member Manny.
Aye.
Manny, aye. Member Costa.
Aye.
Costa, aye. Mr. Chair, motion passes. Item
Mr. Clerk, can you call the second agenda item, please?
Item number 2 is hearing in the status of the May 18, 2011 order of determination regarding Thomas Picarello against Supervisor Carmenchu.
Is the complainant present? No.
Mr. Chair, I don't see him in the audience.
And we didn't receive any sort of correspondence from him?
That is correct. We did not receive anything.
Okay. What is the general protocol when a complainant doesn't show up to an EOT committee meeting? Do we usually table this sort of matter or continue it or what?
Normally we would hear it as a normal
We will hear
case,
it
yes.
anyways. Okay.
Yes.
Okay. Well, in that case, is the respondent present? Or sorry, is there anybody? Excuse me for 1 minute. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thanks for
Hello.
coming.
Hi, Katie Tang from Supervisor Carmen Chu's office.
Great. You have 5 minutes.
All right. I'd actually also just like to preface that we did see correspondence that was sent to the Sunshine Committee Task Force from the complainant that he wanted to ask for continuance, but we said that we had every intention of responding today. So there was an email sent. I just wanted to preface it with that.
Before we begin, can you address that, Mr. Russell?
Mr. Chair, that email came in under 3 days before the hearing date.
Okay.
And if it has to come in well before 3 days.
Sorry.
It has to be, a request for continuance has to be requested 3 days before the meeting date.
Okay.
All right, so anyway, Supervisor Chu's office has every intention of responding today. From our understanding, the complaint filed by Mr. Thomas Picarello, there were 3 issues that he had. One was that the agenda item number 7 on the Budget and Finance Subcommittee meeting held on March 9th, 2011, he stated that was factually misleading. His second complaint was that the item was heard in closed session against the individual's objection. And number 3, that the agenda item concerned funding of 2 city departments and not pending settlement discussions. So in response to his first issue, we just wanted to say that the city attorney and the clerk of the board's office, they collectively draft the summary language and noticing language on all board agendas. So even though our office is not directly involved with drafting the specific language to describe the legislation, it is important to note that the agenda indicated that there was going to be a motion to convene in closed session and that it would be considered and that the item being considered is in connection with litigation. In response to Mr. Picarello's second issue, which was that the item was heard in closed session against his objection, public comment was actually considered on the motion to enter into closed session, and Mr. Picarello's objection was noted as part of the public record. However, upon the advice of the city attorney in accordance with the law, the Budget and Finance Subcommittee, they actually voted unanimously on the motion to convene in closed session on the item. And then finally, in response to his last complaint, the funding proposed is tied directly to pending litigation. Upon the advice of the city attorney, the board considered the appropriateness of and voted for a motion to enter into closed session. So we feel that those address all of Mr. Percarolo's complaints.
Thank you. Is there anybody to present facts and evidence in support of the respondent?
Yeah, Rick.
Thank you.
Hi,
You have
Rick.
3 minutes.
Thank you. Rick Caldera, I'm the Legislative Deputy Director with the Clerk of the Board's office. And in response to Katie Tang's comments is that we do prepare the agenda. My committee clerk actually is the one who prepares the agenda, but in consultation with the attorney's office. And so the attorney's office does provide us with the closed session language, and they are our attorney on record to allow us to go into that closed session, which is what I indicated at the hearing in front of the Sunshine Ordinance Task Force. So that's all I have. Thank you.
Thanks. So this point matters with the committee. Do you have any comments on this off the bat, Romene?
I do not know.
Okay. So, Ms. Tang, would you come up for a second? So I have definitely heard what you've presented, and I just want to sort of clarify, the main sort of purpose of this meeting is to discuss what the task force found, not necessarily to rebut Mr. Piccarello's initial complaints, but so what, in our order of determination, the sort of thing that seemed to be at the essence of it was the idea that the agenda did not properly sort of describe what that item that was being considered for closed session was, specifically with regard to whether or not it was pending litigation or how to fund litigation that had already happened. And so, you know, that also raises questions about whether or not it should have been a closed session to begin with as well. But so I think just to sort of clarify that, that's what the discussion here today should be about, is, you know, what the violations found were. And it was the determination of the task force that while it may have been while the item may have been in connection with litigation, that it was not actually pending litigation, that it was litigation that had happened in the past. And so I also am sympathetic to the fact that this, you know, did come on the advice of come through the advice of the city attorney. However, what reigns supreme here is the Sunshine Ordinance, not necessarily the city attorney's opinion. And, you know, it's understandable that the city attorney's counsel would be trusted in determining, you know, what the letter of this law is. But the fact of the matter is, if the city attorney, you know, gives bad advice, it is the responsibility of the chair of the committee to sort of suss that out and ultimately make the decision about how these agendas are, whether or not an agenda becomes approved. Does that make sense?
Okay, I understand the findings of the Sunshine Task Force, and that is where we are in complete disagreement. It says very clearly on the agenda, existing litigation. In spirit of the Sunshine Ordinance, it very clearly states that we are appropriating $2.8 million from the general fund. So it actually very clearly states that this funding is in connection to existing litigation. You're correct in that the supervisor has the discretion to suss out whether the agenda is properly noticed or the correct language is in there.
Sorry,
And-
not just to interject, not not the discretion, but the responsibility.
The
But-
responsibility
sorry,
to,
continue.
make sure that the wording is correct on the agenda. And that is also why there is opportunity during the budget committee meeting to actually take public comment on whether to enter into closed session. The supervisor determined that the language posted on the agenda accurately reflected what the actual action item was. And in fact, it's all public information. If you click on the document, it's very clearly spells out and shows you what exactly the case is about. And so when she asked committee members whether they wanted to enter into closed session, it was a unanimous vote among the 3 committee members. So each of those 3 committee members also decided that the wording was correct and accurately reflected what was to be discussed. The $2.8 million appropriation, again, public information, but in terms of the existing litigation and what's discussed in the closed session, if you read the agenda, the admin code allows for a closed session because discussion in open session concerning these matters would likely and unavoidably prejudice the position of the city in the pending lawsuits and claims listed below. So in terms of determining whether this allocation should go forward, there are discussions that brings up legal matters that cannot be brought up into the public. And that is why there's a section in the admin code that allows for a closed session.
Okay. I mean, there are elements of what you're saying that I think are right on, but the fact of the matter is it was the determination of the task force that the agenda item did not, in fact, fully reflect and make this clear to someone who's looking at this agenda, and in an attempt to determine whether or not they wanted to come and give public comment, etc., at this meeting.
I'm not sure how much more clear it could be because there was an opportunity for public comment in terms of whether
That's not being debated, whether or not there was an opportunity for public comment. The question is how the item on the agenda appeared.
So may I ask then, since this is an education committee, how do you think we should have properly noticed this on the agenda so that we might not run into this future problem?
It's a good question. I don't have the agenda item.
I have it
in
here
front
if
of
you want
me.
to take a look
I
at
would-
it.
Yeah, I would love to.
I'd love to look at it.
Here's the actual legislation.
Member Kostrom, perhaps you would like to discuss it with DCA 3 before you make known your views. Microphone, please. Everybody.
I would support the clerk's recommendation.
Okay. I mean, that's fine. We can do that.
I'm sorry, what was that?
Sorry, the recommendation was for us to discuss this with our own representative from the city attorney's office, and basically before we give you a formal recommendation about how it would be the proper way to word it would be.
Okay. Is that another hearing though? Because we're going to be entering into legislative recess soon, which is why we actually preferred to meet today.
Mm-hmm.
We can, I don't know, I mean, you don't need to give a formal recommendation. We just want to know in the future, I mean, if this is an education task force, subcommittee, we'd like to know what it is that.
I think that's a completely
because again, we feel that the agenda was very clearly worded in terms of what the action item was.
Thank you for making that clear. I do think that's a reasonable request, to how it should be worded specifically. So we will.
Right. If we can get that in writing, that would be fine. Just the correspondence outside of this committee meeting, because that's just moving forward. I mean, the determination's been made, and.
Mr. Russom, what is the standard procedure for offering those sort of things in writing, as opposed to? Could I after consulting with the city attorney, could I draft something in writing and send it to the respondent?
Frankly, Mr. Chair, I've never come across such a incident, but what you can ask is you can request the DCA to provide an opinion piece and have it sent over to the supervisor's office. So having to avoid them.
That would be fine with us.
Okay. Is that, remember, Matt, should we take a vote on that, or is that without objection?
Without objection.
Without objection?
Yeah,
Is that-
no, yeah.
Okay. That's what we'll do.
Okay.
Would it be possible to copy?
It should
Yes.
be part of the packet that was the original packet. I mean, it's all sunshineable. It should be with the task force. Yes.
Okay. Well, I'll find it. Thank you.
Thank you.
All right. So, with no agenda item 3, Mr. Clerk, will you call the next agenda item, please?
Okay, Mr. Chair. Next item is item number 4, hearing on the status of the May 24, 2011 order of determination regarding Frank McDowell against the San Francisco Municipal Transportation Authority. Agency, sorry.
Is the complainant present? Please approach the stand. You have
Hello,
5 minutes.
5 minutes. As I stand here today, I came here, the last time I was here was regarding the camcorder, drive cam. As I stand here today, I'm a victim of the drive cam. I'm suspended for 8 days. The Sunshine Act, I have yet to receive any information as requested under the Sunshine Act. The Sunshine Act itself sent me a packet from another division, the Patrol Division, that showed that they do have drafts and schemes that would show how they discipline under the drive count. As one of your members indicated on the board there, that he did some research of his own, and he showed that the drive count was initially supposed to be just for training purposes. As I submitted that after our vote, the drive count, management started using drive count for discipline. It's not in our contract. It's nowhere in our memorandum of understanding, but they're using it for discipline. They have no matrix for discipline. There was just a well-publicized incident where a lady was texting. They gave that lady 3 days. I know for a fact that they've disciplined many other people 30 days and 25 days for similar incidents. This has got out of control. These management is they control the income and the outcome of these camcorders. No one there is a professional photographer, a videographer, or whatever, but they're using these things and it's out of control. I think it's a disrespect to this ordinance here for them not showing up. I sent them another letter requesting the drive count. They hadn't answered me. I gave them 5 days, 10 days to answer. Do you want a copy?
Sure.
I told them I would be forwarded to the Sunshine Act. They haven't answered me or submitted any documents. I submitted that to my union, to the superintendent of my division, who forwarded to this Caroline Salaya. I don't know specifically who she is. Again, I indicated that the drive cam is not on the LRVs. They're not on the cable cars. They're not on the F line, but they're on the rubber tires, and we are being disciplined. We are all one union. This is under Title VII of the Discrimination Act 1964 is discrimination. We are all one union, and this is not in our contract. It's in the they voted it in this new contract, but before then it was not in our contract. So this is where I stand.
Thank you. Seeing nobody else in the audience, seems that this matter is with the committee. Well, it's troubling that the respondent has not shown up. Mr. McDowell, so this is something that this is a letter that you sent since?
Yes.
Oh, here's the respondent now.
Mr. Hill's.
Okay.
Okay.
Why don't you take a seat, sir? Mr. Hill, you're actually just right in time.
Great.
You have 5 minutes to.
Okay, we have furnished Mr. McDowell all of the information that we have concerning his request. His request was that we furnish all discipline documents as it relates to drive cam in a matrix. We gave him what we had. Now, it wasn't a standard practice for us to even make a matrix. The drive cam, the only reason we had the matrix that we did was that when we first got the unit, we wanted to see if it reduced driver behavior or increased their awareness of safety. So there were no more matrices that were done since then. We were guilty of not responding within the 10 days. Admitted that at the full meeting. And I also informed the board that from that time we had sunshine training that was done by the city attorneys. I also passed out, and I'll also pass it out again to ensure that, because I only had one copy at the time, of the training that was received by the city attorney, Mr. John Kennedy, and another gentleman. And this is a list of all of the superintendents and operations personnel, including myself, that attended the training, so that we know what the rules are, and no matter what employee that gets it, a request for a sunshine request for documents, we will totally adhere to it. We understand it now. So one of the things, when I first came before the commission, I've only been in San Francisco 2.5 years. I got killed, literally, because I didn't know what was requested and what the laws were in California. And then the other thing was I responded to one thing, but the task force thought I was responding to something else, and virtually it made it seem like I wasn't telling the truth, which wasn't the case at all. So since then, we've done all of the training, as you can see through the slides, back and forth. We asked questions. This training was for 2.5 hours. Everyone's name you see on there, including mine from operations, was there. we have informed all of our staff if we get any sunshine requests, if it says sunshine requests or public information or request for information immediately, that information is to be forwarded to Carolyn Celaya, who's really our liaison at SFMTA. Now, when we were guilty of this particular case with Mr. McDowell, we hadn't had the training at that point. It hadn't filtered all the way down. So we did violate the 10 days. We admit that, and we did. But in the future, I made a commitment to the task force, and I'll reiterate it again, that anyone that's up underneath my umbrella, if we get a request, we're going to respond within the time limit that's designated. The other thing we understand is that whatever documents that are requested, if we have them, we're going to forward them, unless it's something that the attorney says that we can't. And I don't understand all of those rules, but there are certain things that are attorney-client privilege. In this case, the information we had, we gave freely to Mr. McDowell. He has what we have. There are no more documents. There are no matrices. There was no reason to even do it. So it's kind of an unusual out-of-the-box request that he made. But any request that he has for any other information, we freely will give forwarded to him. Thank you.
Thank you. Mr. McDowell, this letter that you just gave us.
Yes, sir.
So this is something that you sent.
Yes, I gave it to my.
Sorry, you sent it on. Is it date? I
June
see when it
1st.
was. It was
June
on
fir-
June
June
1st. Okay.
Yes.
And have you received anything in response?
Nothing at
to it?
all. Nothing at all.
I know. I just want to clarify something.
Nothing at all.
All right. Thank you. Have you submitted any sort of complaint with regard to this?
Chris had been gone for a couple weeks. Before I called your office and I didn't have a complaint form. You just sent me a letter. I just received it yesterday with a complaint form in it. So I could not. He was gone like for 2 weeks or so.
So you've been in contact with the clerk about this.
Yes.
Okay. Thank you. That's
this
all.
This is the ordinance by the. I was over rubber tires on this camcorder events. That it says that drive cams cannot be.
So we're not going to be able to talk about that specifically right now, but I do that you'll be able to talk about that in whatever sort of hearing you schedule with.
But your office has sent me graphs of discipline from patrol districts. So Mr. Hill is not telling the truth.
So that will remain to be determined at a future hearing. But I do have one more question for you. So is this letter here requesting essentially the same information that you're requesting in your last one, or is it requesting different information?
I've explained even clearer what I'm looking for.
Okay, thank you very much. That's exactly what I'm looking for. Thank you. Mr. Hill, will you come up for a second?
Yes, sir.
So first of all, thank you for coming. I appreciate it. And also, I'm glad that you seem very sort of aware of exactly what the finding was of the task force, and we definitely appreciate your commitment to training the staff and your commitment to going forward, making sure that all requests are served in a timely fashion. What I'm a little bit troubled, and I guess I can't say anything for sure because the full task force hasn't heard evidence on both on both sides of the equation. But what it sounds like to me is that Mr. McDowell has written you another letter looking for information dated June 1st, and is saying that he hasn't gotten any sort of response. So we're not going to hear that case right now, but I guess all I can say is I'm a little bit concerned that if that's the case, how that squares with what you just said about your commitment to respond in a timely fashion.
Well,
And I just want to clarify one other thing, and then I'll let you sort of respond.
Thank you.
If it is a letter requesting the same information or information that you don't have, it is still necessary to, within that 10 days, just at the very least, offer a response saying we don't have this information and we therefore can't fulfill your request.
Okay, well, actually, we did. We sent him a letter that said, we've given you all of the information, and we also asked for clarification if there was anything else. But just so that there isn't any misunderstanding, I will again send him a copy, and I will mail it to his address, certified mail besides regular mail, and also issue it to him in the division. The problem is that he's not satisfied with the information that we have, and he wants information that doesn't exist. So he makes another request for the same information, even though we said we've given it to him, but then he says he doesn't have the information that he wants, and that's where the disconnect is. So we can't give something we don't have, even though he wants it.
Thanks. And so just again to clarify, we're not going to be able to get into discussion of or consideration of the facts of this particular interaction, but I just want, seeing as this is an education meeting, I just wanted to make sure it was clear that going forward, no matter how many letters you get or whether or not you have the information that any of them are requesting, it is under Sunshine, you have to give a response within 10 days, saying either giving the information if you do have it, or if you don't have it, explaining that you don't have it and that you won't be able to give it. So I just wanted to make sure that was...
Yeah, that's a point that no one brought up, is that if we've already given it and they request again at a different thing, we just give them the same thing as many times as they ask. I wasn't aware of that, but I will make sure that we do it, because there's no problem with that either. And also, I'd like to say that I really, and I said this before, sincerely want to work with the Sunshine Task Force. Number one, I have to, but number two, it just makes sense. And if there are any issues, I want to make sure that we abide the way we should abide. Now, I'm not responsible for the whole 5,500 employees at the MTA, and they're under different departments, but I've put the word out, and even when I did the training, I asked for other departments to send their heads to come. Some did, some didn't, but everyone in operations, which is about 2,200 operators and another 400 or 500 support staff, we know, and then some people came from MOW, and it's my hope that all of the MTA would take the training, and every organization, because now that I've been through it, the city attorney did an excellent job. We asked questions. They really did a good job in doing the training, and it helped me to understand what we needed to do, and not just me, my superintendents and whatnot, so we don't come down and continually be out of compliance. So I think right now where we are is that there may be one or two separate cases out there that wasn't in our department that was outside of the time limit, and Caroline is working with them to help them understand it. Hopefully we can be a model agency, and if I was at the head, which I'm not, for the record, I would make sure we were in line with the rules and regulations.
I think we definitely appreciate that sentiment, and you should consider the line of communication open. If we want to help you as much as we can be in compliance, and help you and other agencies understand the rules essentially regarding Sunshine. So if there are ever matters of a lack of clarity or anything, you should feel free to get in touch with Mr. Rustum, and if you ever want additional trainings, you should also feel free to get in touch with Mr. Rustum, and we can set those up.
Right,
So.
Thank you. And I do have one question, if you could take it, because I was getting mixed signals. Before you actually go before the full Sunshine Task Force, they send out a letter, and it says that it has to do with jurisdiction and so forth. And I've been told that we don't have to go to those, even our attorney. But it seems like to me, is that an arena where you can come and explain what all has happened before you go to the full Sunshine Task Force? Like a committee like this, is that the avenue that you can come and explain so that you don't have to go through the whole?
May I answer that through the chair? As soon as we get a complaint, I try and resolve it before it goes to the committee level.
Oh, okay.
And most of the time is, I asked for this, I did not get that. So there's no way I can solve that issue. Sometimes, I'd say about 20% of the time, I explain to the person what the way you need to ask for it, what the documents, sort of clear cut questions. And I also informed the respondent that you have to, if you have it in your possession, you have to provide it.
I see. That's
So
the first
that
time?
is done before that first letter goes out.
I see.
When that letter goes out, it means that the department has contested jurisdiction, or number two, the complainant has a lot of issues that he wants the committee to resolve,
I see.
rather than myself.
Right. That is a misconception on our part, because we were told the only thing is determines jurisdiction. They have jurisdiction, so you don't go. And I'm saying, well, it would make more sense if you could, seem like everybody has some kind of committee where you could go, sit down, and say, this is what we have, this is what we do, what do we need to do to resolve it, rather than go before the full. That just makes sense. So I'm most certainly going to carry that back and let everyone, because I think a lot of our problems or whatnot could be resolved at a much lower level. So this is more education for me, and I really, really appreciate that. And can I have your card, or your name again is
Yeah. Please feel free.
My name is Chris Rustum.
right? And if you have a card and phone number, because I'm gonna get it and go back and also tell our folks, because we have been told that when a letter comes, you have jurisdiction. We're not contesting that. That's what even the attorney said. And so you go before the full Sunshine Task Force, and so, wow, that is something. I'll tell you, this is worth the trip. Thank you. That's all. And really, I appreciate you. And also, Mr. McDowell, I'm not against you either. I'll give you whatever it is you request that we have. Thank you.
Is that so? If you want, you have the opportunity to say any concluding remarks, Mr. Hill. If you, no, not necessary, but if you want, you have.
Just want to thank you, and thank you for allowing me to ask the question, and also thank you for allowing me to explain. Was running out of a meeting trying to get here, and of course it was a situation where they were saying, well, they've already decided we're 10 days late, so why are they having a meeting? I say, I don't know, but I'm going to go down there to find out, because it may be something else. So anytime I see anything that has to do with our part, whatever I'm doing, I'm going to come or make sure that we have someone here. So most certainly, thank you. And this is a much better venture, because I stayed to 9-something, which is really brutal. But I just appreciate both of you. Thank you.
Thank you. Mr. McDowell, you now have the opportunity to say your piece.
Thank you. Again, I have, do I have to submit another document, or would that letter be submitted?
I believe it. Let me just clarify briefly. It sounds like there's already a process in place that you've already corresponded with Mr. Russom, and there's already sort of a hearing being set, or is that correct, Mr. Russom?
Mr. Chair, I have sent Mr. Darwell the complaint form.
Okay.
Once I receive it, I'll start the process.
Okay. So yes, basically you
After we
would.
file.
You'll just fill out the form and send it back to Mr. Russom, and he will take care of
I
the.
received that yesterday.
Okay.
Now, where we're at is that the task force itself sent me a graph. Dorian Maxwell sent it to you. You forwarded it to me. It showed that they do have in their capacity to show the discipline being used, the discipline, the types of discipline, what they're being disciplined for, how much they're disciplined. They sent us color codes. They did nothing to show how they are disciplined, whom they are disciplining. They're withholding evidence to show what they're doing. Furthermore, we got to find out what gave them the right to discipline. It's nothing in our memorandum of understanding to allow the drive count to be used. They are using it. They are using it, and it's extortion to the highest degree. They're disciplined people. That's all I'm asking. If they have, where is it that if no side letters, what gave them the right to even start? Your person sitting on the board said that he did deep research. He went back to 2009. He showed that this drive cam was supposed to be used only for training purposes. How did it get to discipline? Thank you.
Actually, if you would just stay up for one moment. So I just want to sort of reiterate, we won't be able to dig into these issues in this committee because that's something that the whole task force will have to be present for. And if you do fill out the form that Mr. Russell sent you, I assure you that we will give that the full consideration that it deserves.
Thank you.
But the matter at hand right now is the violation that was already found, which was the lack of timeliness. And so I did just have one question for you. Mr. Hill said that he sent you or that you were sent a response to this saying that they didn't have any information. Is that correct?
They sent me a letter asking for further clarification.
Okay. And was
that-
that within 10 days?
No, it wasn't.
Okay.
No, it wasn't.
Okay.
No, it wasn't.
Okay. Well,
It came from the Mr. Solaya he's been speaking with. So I came back with that letter, and I haven't heard a thing.
okay. Well, thank you very much. You can take a seat.
Thank you.
So my feeling on this is, Mr. Hill, I'm very much trusting your intentions, your stated intentions. You can just take a seat, and I very much look forward to the MTA living up to its desire to be a model agency under the Sunshine Ordinance. So, Member Mena, do you have any comments on this?
I do not, but I just want to echo Chair Costa in that I also hope that as we move forward in Sunshine meetings that the MTA is an agency that exemplifies good sunshine as we move forward.
So without any objection, we'll conclude this particular matter. Seeing none, matter's concluded. All right, is there any public comment for items not listed on this agenda?
Public comment on item number 4.
Oh, well, is there any, the chair will note that there are no members of the public present to comment on item number 4. And so we'll move on to item number 5.
Item number 5 is public comment on items not listed on the agenda.
Yes.
It's not listed on the agenda. If you have a comment on something that's not on the agenda. Do you? Oh, okay.
Okay. Seeing none, public comment is closed.
Item number 6 is committee members' comments, questions, and requests for future agenda items.
Let's see. Do you have any questions, Member Mena?
Were we supposed to have a training for someone
Yeah.
coming up? Or did it already happen? Shame on.
That is coming up in September.
Oh, it's in September.
So do we need to, at what point would it be appropriate to
It will
determine?
be towards the end of September,
Okay.
so we can discuss it at the next meeting.
Okay, can we put that on the agenda for next meeting? The other thing that I guess we should probably also put on the agenda for the next meeting, or I don't know to what extent we can talk about it now, is that there was something, actually it was brought up in discussion at the last task force meeting, basically maybe trying to generate some sort of plan for working with the city attorney's office, because it seems like they're giving out a lot of advice about the ordinance, and sometimes, in fact, I think that this presentation here that Mr. Hill gave was actually the city attorney's sunshine presentation.
That is correct. Yes.
And so maybe, I don't know if it's possible to consider this more closely and make sure we, are in concurrence with everything that's being said on here, or maybe talk with somebody at the city attorney's office about, points of contention that we have. It seems like that would fall under sort of the duties of this committee to sort of make clear the task force's interpretation of certain sections of the ordinance, and at the very least sort of register our disagreement with advice they're giving out. I don't know.
The brutal, frank answer is we will never see eye to eye.
I understand that, but I think that it's our responsibility to try. And so I don't know if.
Let's give it a try.
Well, perhaps a good place to start is with something like this, and making sure that, explicit sort of educational pieces, there are not egregious places of, that we disagree with. So maybe now that we have a copy, maybe I'll try to take a look at it for next time, and
Review it
anybody
more
else who
closely, yeah.
feels interested in doing that too. And would it be possible to have a discussion about any problems that we have with it next time? What's your hesitation, Mr. Weston?
It's what this ties into is the amendments package,
How does it tie into the amendments package?
because as we go about the amendments, we see where the gaping holes are.
Yeah, I just want to make sure that specifically no wrong advice under the current language is being given out, or that the advice that's being given out is as clear as possible about the current language. Basically, that it matches as closely as possible a presentation that we would give. I think that there shouldn't be mixed messaging about
That's
the.
right.
So, anyway, that's something I'm interested in trying.
I'll put that on the agenda, Mr. Chair.
Thank you. Are there any other requests for future agenda items, or questions or concerns? Okay. Well, without objection, we will adjourn this meeting.